Let me know when you're ready.
It's loading. Give me just a second. All right, we're good.
All right. This is the issue subcommittee to study sick leave policies for April 1, 2021. I'm addressing the members of the committee today. Members of the subcommittee are hereby advised of their duty under the State Ethics in Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before the subcommittee with respect to which there's a conflict of interest or an appearance of conflict. Does anybody have a conflict with respect to the proposed work of this subcommittee today? If none, we'll proceed. As an introductory matter, as I just alluded, we had the perfect vortex that should have kept more people out. I'm really happy that you're joining us today. I realized too late this was in this day falls in the middle of spring break for many people. It falls within the travel allowances of Easter holiday for many people. And for those of you who still look like you could use a little more sleep, it's the last business day before the holiday. So it's a perfect vortex. So I'm very, very happy we've got as many participating as we do. Now, the first item on the agenda is the review of assessment areas. We're not going to go over it word by word, but for those who were not here last time, these are items that are going to be core areas of inquiry and core subject matters for the possible report that'll be rendered to the Issues Committee at the conclusion of the subcommittee's work. If at any time during the process of doing our work, you think something should be added topically, then please speak up and we can always add to the list as we get further into our work, or we can delete things that appear not to be worth chasing. So this is sort of a organic part of the agenda that you'll see each and every time, and we can add, we can delete, or it may stay as it is until we start writing the report. Let's see, I may have missed the approval, or didn't even list it, of last month's minutes. They are attached to the agenda, and I request any and that you, if you've read it, if you've noticed anything that does not appear to be correct, and now is the time to suggest any changes or modifications or corrections. All right, if none, I ask for a vote by audio of as to approval of the minutes. All in favor of approval, say aye.
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 Very good. Thank you. Oh, and by the way, I almost forgot my manners. Do we have any officers attending today by Zoom? That was the perfect vortex part, right? Okay, very good. We'll start at number 4. We're in the process of trying to identify other stakeholders who may have some beneficial input for our work. And at the last meeting, we eliminated a lot of potential stakeholder groups and types and focused on those that you see listed A through D. Darren Jordan took responsibility for reaching out and trying to get an idea of whether LAP would like to have some input into this process or have somebody monitor what we're thinking about. He did that and got in touch with Robin Morades, and Robin has put forward a person by the name of Shelley Buckner from Cherokee, North Carolina, Swain County, who has professed interest in what we're doing and has some connection with the work of the LAP board. I don't know Ms. Buckner. Does anybody know her? Okay, if not, unless anybody has a better idea, I think I'll just reach out to her. I got the name and the telephone number a little too late to call her today, but I will do so, and then that will take care of Darren's responsibility for LAP. Administrative Office of the Courts and TCAs and TCCs. This shifted around a little bit. I got a really good email from Drew Edishek, and Drew, in addition to dealing with the Appellate Rules Committee, also recommended that we may want to talk on the administrative judges down below Mel Wright. I spoke to Mel Wright, and Mel and Drew had suggested that we talk to Julian Mann. In the process of talking to Mel Wright, who had undertaken the possible contacting the administrative offices of the court, he suggested that the contact there should be, let's see, David Hoke. And in the process of those exchanges, it became my job to call David Hoke, because I had done a lot of work for him a long time ago in certain matters, and I had an opportunity that not to have to reintroduce myself. I'll come back to that in a minute, but that's how that assignment ultimately got to me. I'll save that for last. The appellate rules and administrative judges topic at the bottom, D. Drew, you're on. You're on this
Sure.
call.
Yeah.
Yeah.
Hey, Gordon. Yep.
Do you want to summarize what you suggested to me about the appellate rules side, and then what you were recommending as far as administrative judges?
Yeah. So on the ALJs, as I mentioned, I think it makes sense, to have somebody from OAH, and if Chief Judge Mann is the right person to do that, that would be great. I know Gordon, you and Mel know him well, and could talk with him about it. On the appellate rules side, I was just thinking that any changes we might make to the rules would involve a change to the appellate rules most likely, and the court's probably going to ask the appellate rules committee what they think about it. So that would make sense to have somebody sort of along for the ride. I'm the current chair of the appellate rules committee for another 2 months, thankfully not longer than that. So Justice Barbara Jackson is going to be the incoming chair. I can talk about it with Barbara, but I think just to not add, to sort of keep adding folks to this committee, and with the fear that it could be a 50, 60 person committee. I told Gordon I'd be glad to sort of play the 2-for-1 role of, sort of hanging around on the appellate rule side, since I'm going to be here in these meetings anyway. So, and I talk with Justice Jackson, probably daily on these, on various issues anyway for appellate rules. So she and I can keep her in the loop.
Yeah. And I thought his thinking was sound. Draft one, get one free kind of arrangement. I would like to keep this group small and nimble if I could. So I think, given the fact that you're already on the committee, that I think you'd be able to have input from your experience there, and you've got access to other committee members, particularly with Justice Jackson coming on board soon. And I think that would be perfect. So unless somebody thinks otherwise, I'm going to proceed that way. And so that part of the stakeholder will be filled by Drew and by his connections with the committee. On administrative judges, you suggested Julian Mann, I believe. And then Mel Wright also knew Julian Mann and was thought that that would be a great idea because he is the chief judge of the administrative judges, OAH. And so I talked to Mel about it this week, and again, he thought that would be a good idea. And so I've reached out to Chief Judge Mann to see if he's got any interest. And I did that in writing, but I've not yet heard back from him. Again, it's that perfect vortex, and he and Diane may be somewhere visiting children or otherwise. So I hope to hear from them soon. And then while I was talking with Mel, he was working up his game plan to try to think who from the superior and district courts he might call upon. Mel, have you made any further progress with that?
I have. I got the names from David Hoke, of the head of the Superior Court judges and district court judges. The Superior Court judges currently headed up by Judge Phyllis Gorham from the 5th District, and District Court Judge Sherry Elliott from the 25th District. I've been able to speak to Judge Gorham, and we talked about this topic, and I asked her if she had ever encountered any type of problem with the secured leave policy. Anybody ever suggested any changes or how to modify it or anything of that nature? And she said that there had never been any question in any way, shape, or form that she was aware of, that people had always been happy and pleased that they have that secured leave so they can lock in vacations and trips and that sort of thing. So she knew of no complaints and no reasons to add or modify, but she didn't say we shouldn't. But so she was very positive about the secured leave. And as far as she knows, all the Superior Court judges are. I called Judge Sherry Elliott twice and left messages. And I have not yet been able to talk to her in regards to the district court judges. But Superior Court judges are very favorable towards the rule. Don't know about district court judges, but my guess is they're also supportive.
Very good. Anything else you'd like to add about that?
No. I'm certainly glad to be a part of the committee because I think this is an important topic, and if we need to amend in some way, I'm going to probably be in favor of that as well. But at this point, I'm just happy we have it.
Okay. Well, you're reporting that way about Judge Gorham, and she's very experienced and in a busy district. So
she's on several committees too.
Yes, she is.
Very busy.
Do you think, and this is an open question for everyone on the subcommittee, when we get responses like that from someone in a position of leadership with a group that we've identified as a possible stakeholder, is there any need to go any further than that, or should that be the input we just rely on? I mean, I don't want to go chasing Superior Court judges to find anybody with a different opinion, or adding up how many also say favorable things. But should we stop there?
It does seem like it might be sufficient to me, absent some, vocal opposition, Gordon. I'm not sure. Yeah, I'm not sure we need a lot more, is my reaction.
Yeah. Anybody feel differently? I agree. I think Judge Gorham told it like it was from her standpoint, and she's in a position to know. I don't think we need to go any further than that. Mel, will you check in with Sherry Elliott, continue your efforts there, and just
I sure will.
for the next meeting, let us know what she might say.
Yes.
Now, it's interesting getting back to my part with the AOC. I've talked to David Hoke, and David said even though he is the air traffic controller for court scheduling in this state and would appear to be in a position to know, he says he knows very, very little about the secure leave policy in North Carolina, other than that it exists. It is not tracked, nor is it managed at the AOC level. It is completely local, district to district, in the way that it's handled. And he says that in all of his time at AOC, he's never had any issues pop up concerning secure leave policy at that level. In fact, he said that he's complimentary of the fact that one exists, because where he is benefited by the rule is whenever he is charged with arranging special sessions of court or Rule 2.1 sessions of court. And it is so much easier to go to that jurisdiction or look up the attorneys and find where they have designated time in the future that the setting of the sessions need to respect. There are less false starts, it's more dependable, and because it has to be declared in advance, avoids the sudden, oh, we were going on vacation that week, Your Honor, problem. So he was complimentary of it, said it was helpful to have, does not run into it much. So from an AOC level, like with the Superior Court Judge Gorham, I'm not sure what more he could put into it. He did say that if anybody on the subcommittee had any specific questions, he's happy to get on Zoom with us at a meeting and answer those questions. Otherwise, he thought his answer was sufficient on that. So does anybody think David Hoke might have some questions of David Hoke that I didn't think of or may have asked him? That may be one we can check off as well. Okay, if that's the case, then in summary, AOC and the is one I think we've talked to a stakeholder. I know it's not something that will impact that. LAP, I'm going to see if we can get Shelley to the next meeting. We've got a report on conversation with Sherry Elliott to be had. We've got our appellate rules person in the house, and Judge Mann is outstanding right now. Maybe when he gets back to town, we'll hear from him on it. Okay, before we leave this topic, does anybody have any questions, comments? Okay, let's go on to information survey. The latest iteration of the questions for a possible survey are attached to your agenda, pages 8 and 9. We got some feedback. I think Savannah heard from Catherine Fry. Darren Jordan added some comments regarding the mental health aspects that you'll see in there. And I heard from Kevin Kiernan that he had looked them over and didn't have any additions. But this is the first time everybody's getting to see these particular ones. I don't know if it's worth the committee's time to go over them one by one, since everybody here is literate, but we can do that if that's your wish. But we need to be getting this finalized. I'd like to have the survey go out sometime later this month so that we'll have something in hand maybe as early as May or maybe as late as the June meeting, because I think we'll be getting a lot of information from the survey. Let's just do this as a means of starting on this animal. We need to decide who the recipients of the survey are going to be. I don't think we're prepared to send it out to 28,000 lawyers who are licensed, but we have identified some groups. And let's see, Savannah, you had a list of those, I believe, last time, didn't you?
Yes.
What groups?
So I think we are looking at sending it to the State Bar Council members, sending it to the Advocates for Justice, because that's a good group of litigators that will likely or have likely had to use secured leave before. And then 3 separate divisions of the North Carolina Bar Association, the Litigation Practice Division, the Appellate Practices section, and the Young Lawyers Division. I have in my notes from our last meeting that we really want to make sure that we're sending the survey to a very broad and diverse group of lawyers through this. And so just want to ask the question, does anyone have another group in mind that you think should be added to make sure that we're reaching out to a full spectrum of lawyers and the types of lawyers that are litigating every day?
I think you ought to add
Okay.
the Association of Defense Lawyers.
Good, Mel.
Savannah, you may have mentioned this already, but maybe folks like even like construction, like the construction law section or the land use section. I mean, a lot of those folks are they're as much litigators as I am.
Okay.
Just a thought. I can even go through those sections and sort of quickly identify and just email you separately who sort of the sections that have a lot of litigators in them, even if they're not litigation per se. If that makes sense.
Yeah, that would be helpful.
Okay. Yep.
Are there any sections that we also need to focus on that may practice before or the Office of Administrative Hearings?
Yeah, I think probably so, right? There's the administrative law section. I used to be a member. I think it's the administrative law / regulatory, but yeah, I'll take a look at that. I'm going to pull up a master list of sections while we're here.
Savannah, did you mention and I'm sorry if you mentioned that, I didn't catch it, those who practice family law in the family law section?
I did not mention the family law section. No, I did not. Thank you.
Good suggestion. I think they definitely need
Yeah.
to be included.
And Savannah, if we're looking at trying to get a diverse crowd besides just practice areas, I don't know if there's specifics on the Association of Women Attorneys or the Black Caucus. I forgot what the official name is, but I just didn't know if that would be helpful, and if they have these particular demographic groups would have different feelings about it, no matter what their practice area is.
Okay.
Savannah, so looking through these, this list, just in alphabetical order, I'd probably send it to administrative law. I'd probably send it to the antitrust and complex business disputes. You mentioned appellate practice. I'd probably send it to bankruptcy, even though a lot of it's federal, but a lot of it's state court creditors' rights type stuff too. I'd probably skip business law. I'd maybe send it to the constitutional rights and responsibilities, maybe send it to construction law, probably skip corporate counsel. I'd send it to criminal justice, maybe skip dispute resolution, maybe skip education law, maybe skip elder and special needs law. I'd probably include the environmental folks because a lot of them litigate. Probably skip for sure estate planning and fiduciary. I think Walter's suggestion on family law is great. I don't know why they didn't come to mind for me first. They probably more than anybody needed. Those folks have got it. Yeah. Probably government and public sector too. Probably health law, maybe insurance law, IP stuff for sure. Probably not so much international practice. Maybe not. Well, actually, probably juvenile justice and children's rights. Probably labor and employment. You mentioned litigation. Maybe not the military and veterans law or the privacy and data security or real property, or I would do small firm and technology. I probably wouldn't do sports entertainment law. I probably wouldn't do tax, probably would do workers' comp, and I probably would do zoning. But those are, as you can see, I'm just doing this in real time. These are sort of like my immediate thoughts. They may be garbage thoughts. So if folks don't think that those belong or think others belong, by all means.
I've made a list of those as we were going down the list, and for more than just Drew, and we'll include the list in the minutes as we're putting together a list. Is there, that I have not been particularly active in any of those groups. So is there a way that we could go through the Bar Association to get the survey out to these different groups if we are not members? Gordon, do you know that?
I think I know someone who may have the answer.
I was hoping you would.
Yeah, and they have the lists are available by section with all contact information. So I imagine they can get the list out in some kind of mass distribution way. All we have to do is either request the bar or request the section chair to approve putting his or her people on the list. But I can work through that protocol with this unknown resource that I have.
Okay. Are there any other recipients that we can think of, or do you want me to proceed on to discussing what sort of platform we want to use?
Yeah. Before we leave groups, and I think this is a substantially improved list. Any more nominations or proposed additions? All right, if not, let's go to the survey platform. Savannah, take it away.
So I discussed with Gordon that I don't think that the survey that I sent out using the Microsoft Forms program was going to be the best way to send the survey out to a large group of people, in large part because it doesn't allow me to, or allow the subcommittee to look at how a different group of people answers the questions. If we're looking at young lawyers versus older lawyers or more experienced lawyers, and the way that they answer the questions. So I've looked into it a little bit. I think that we should still be able to use a free survey source, maybe like SurveyMonkey, to disseminate the same kind of surveying and be able to look at the results week back and analyze those. So I think we'll be fine. And I think SurveyMonkey should allow us to do what we need to.
How expensive is it to disseminate that?
The SurveyMonkey says that it's free to just use and create and send a survey. It may become a little bit more expensive depending on what kind of analysis we want to do of the responses. But I don't think it would be more than maybe $50.
Do we need to get approval from the state bar before we commit to $50?
We might need to do that and take it through the issues committee to see if they will authorize us to spend that money to use SurveyMonkey that way. I have an account with my state bar email address already. So I'll just need to play around and report back to you before the April meeting about whether or not we are going to have to use one of the services that cost money.
Okay, that'll be good to know going in. And if we need to request the issues committee to authorize some funding for that, then we can take care of that at the April meeting. Keep us on track.
Yeah.
All right. Any questions of Savannah relative to platform and the mechanics and the technology? All right. If not, the survey questions are there. And I don't like giving homework assignments, but I really would appreciate it if you would take a look at that after our meeting is over today. I think I'll set a deadline for further submissions for the questions to coincide with the State Bar Council meeting over in April, some 2 weeks hence. And then we'll have authorization to go forward after having run all of this by the issues committee, hopefully, and we can go ahead and get the questions out. I think we can start moving in that direction, but Catherine is not available to us today, and she's on the group, the gang of three, as we call them. And I think I want her to have a little bit more input and make sure she got all of her suggestions in there. And Darren Jordan is also in the gang of three, and I want him to have an opportunity to see if what he wanted in got in. And I'm looking forward to getting any further comments or possible modifications from people. So if you don't mind doing the homework, I'm not going to flunk anybody, but it helps. I believe in the wisdom of crowds, and we've got lots of crowd that we can benefit from. Any other comments relative to the working list of survey questions? Okay, just back from Las Vegas, where you put in an appearance discussing various types of secure leave policies nationwide. Cameron has come to us with his selection of the week.
I can't imagine what Vegas would be like right now, and I don't want to imagine. So as according to the agenda, I'm to discuss Virginia, Florida, and Georgia, and I'll do them in order of how substantial their respective policies are. I'll say that at this point, we've gotten about 10 responses to our email blast that we sent out on the NOBC listserv. And so far, the only 3 jurisdictions that have any sort of policy protecting attorney leave were Virginia, Florida, and Georgia. The counsel that replied to us from Virginia said that the only attorneys who get any sort of secured period of leave are attorneys who serve in the Virginia State Assembly. And they're able to take secured leave during periods when the assembly is in session. In Florida, they don't have any general law allowing for attorney secured leave, but the Supreme Court of Florida recently promulgated a rule that allows up to 9 weeks of parental leave for new parents. Strangely, this rule applies only to civil trial attorneys. And I actually found an article about it, and it sounds like if you do criminal law, domestic law, juvenile law, or anything other than civil trial work, you have to go about getting your leave the old-fashioned way, which is through their general rule governing continuances, which is not nearly as favorable as this new rule allowing for parental leave. I don't know that Florida rule is going to inform our rule very much. We have a more generous parental leave policy already. I believe the first 24 weeks after a child is born, you can designate up to 12 periods of secured leave as a new parent in the state of North Carolina. Georgia's rule is the most comprehensive and I guess the most comparable to ours, although there are differences. And we have attached the 4 rules that cover attorney leave, and this is from their general rules of Superior Court, and they've got a similar rule for each of their trial divisions and for their appellate division as well. Georgia Rule of Superior Court 16.1 covers leave periods for 30 days or fewer, and an attorney is entitled to that for any reason. And basically, the mechanism, the way you get it is you have to prepare a designation form, which they include in Rule 16.4. So it's kind of idiot proof. You know, they have a general statute or a general rule form that you can use. You have to submit that notice 30 days prior to the beginning of your designation period. The Georgia rule actually allows various opposing counsel to object to your request. So once they've received notice of your designation period, they have 10 days to object. If they don't object, then your leave is granted as a matter of course. And you can have as many leave periods theoretically as you want under this rule. There is no limitation as there is in North Carolina. Although I would imagine that courts would probably step in to prohibit, and prevent abuse of this provision. The language of the rule admits of no limitation on leave periods. And if you want to take a look at Rule 16.2, this governs leave periods of greater than 30 days in length, or leave periods for cases that have already been calendared, or leave periods that are just not filed for in compliance with Rule 16.1. And I forgot to mention that Rule 16.1 only covers cases that haven't yet been placed on a published calendar that require an attorney's court appearance, or for which a hearing has not yet been noticed. So anything other than that would have to be dealt with under Rule 16.2. Rule 16.2, it requires that opposing counsel, all of the various opposing counsel that an attorney might be treating with who is trying to obtain this form of leave, receive notice that the attorney intends to request the leave 10 days prior to the request being submitted to the court. The attorney can object, the attorney can consent. Whatever the attorney decides to do, though, unlike Rule 16.1, which is, you apply, nobody says anything, you get the leave. Under Rule 16.2, whether or not the attorney is granted leave is always left to the discretion of the court. Georgia has no provision for parental leave, and so I assume that if somebody wanted to get leave of that sort, they would have to apply under Rule 16.2. Rule 16.3 is kind of just a generic statement of what this protected leave does, and it's very similar to what secured leave does in North Carolina. Basically, you can't be hailed into court for a trial or a hearing. However, any deadline that is set by law or by a court, you still have to comply with, even on your leave period. So presumably scheduling orders, statutory filing deadlines, things of that nature, the lawyer still has to comply with those. And 16.4 provides their sort of form application for designated attorney leave. And as I said, I think it makes it sort of idiot proof. Basically, if you don't submit a request in this form, then your request will be denied. And that was my very long-winded discussion of the Georgia rule on attorney leave. And if anybody has any questions, I will address them to the best of my ability.
Cameron, what's your appraisal of the Georgia approach? In comparison with North Carolina's?
I think there are quite a few similarities. I think some of the major differences are the content of the designation. In Georgia, it's basically list the cases that you want protected, list the reason for your leave, and list the duration, and that's all. And if you look at our rule, Rule 26, Section D, we require quite a bit more of the attorney by way of an explanation. And we also require assertions that the secured leave period isn't being used for any impermissible purpose. I am interested by the fact that you've only got to file 30 days. I mean, you've got a 30-day window to file rather than a 90-day window. They have a considerably shorter notice period. You know, I don't know whether or not that's caused problems for them. But you know, that I think that is something that had been bandied about in earlier discussions, both by the subcommittee and by us before the committee began meeting. But otherwise, I think it's fairly similar. You know, it is a little strange that there's no limitation period. You know, you could theoretically take as many periods of leaves for 30 days or less as you want, which just seems like a bad idea and like a thing that could be subjected to abuse. I do like that ours does place some limitation on the number of leave periods you can take. But they've also got flexibility in that the length of their secured leave period or their attorney leave period under Rule 16.1. I mean, it could be 1 day, it could be 29 days, it could be a week, it could be 2 weeks. You know, that flexibility, I could see that being nice. I mean, and that's a pretty substantial difference.
They say it's 30 calendar days.
Yes.
So is that the equivalent, because courts don't usually work on Saturdays and Sundays, and it's not requiring consecutive calendar days. That's the equivalent of 6 weeks.
6 weeks, yeah. If assuming that it's read that way, or assuming that it would be interpreted that way down in Georgia, but I would think so, yeah. So they double our leave period.
Yeah. Okay. Anybody have any questions of Cameron? And you're continuing.
Yeah, I'd be interested how the flexibility of that to be able to pick 1 or 2 or 3 days just at random. I'd be interested to see whether that would be helpful to lawyers. What, I can't remember right now. What do we have to take a week at a time? Is that what we're required to do? Yeah.
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 Yeah, it goes Sunday to Saturday.
Mm-hmm.
And if I realize I am only counsel to the committee, but I do, you know, I spent a lot of time before I joined the state bar in criminal district court. And the idea, I mean, where you're in court every day, you're potentially trying cases every day. And the idea that you have to take a full 5-day block rather than say 2 or 3 days. I mean, say you want to take a Thursday and a Friday, and, you know, if you have the option of taking just Thursday and Friday, that leaves Monday, Tuesday, and Wednesday open for trial work. And I mean, you know, when you're trying to cram so much into you know, 5 days a week, it's better to have or I would think it would be better to have the extra 3 days than to require the attorney to take the full week. But I don't know. That's just little old district court me talking.
Does anybody know the reasons why we had a minimum of a 1 week block?
Drew, I think you were involved in some of the early drafting or even the current policy itself. Do you have any recollections?
So yeah, so I was not actually. I think I can't remember who had said that, but I was not. I think Mel was. I was sort of watched from the sidelines on on some of the recent parental leave issues, but not on the original formulation of the rule. But Mel, Mel, I want to say you were pretty involved in that rule. You may have even been the author. You're on mute, by the way, Mel. And I see your conclusion today with the news out of Chapel Hill. So
Yeah. We'll take the most important thing first about Roy, but no. The discussions when we started talking about this, we were afraid that if we allowed 2 days or 3 days or 1 day or whatever, that it might become too much time and effort for the judge's office to have to deal with that. Whereas if somebody was going to take a vacation, usually it would be a week or 2 weeks. And I mean, that's one of the things that I think we should discuss now, of whether or not we need to make it less than a full week. And then, but I think from the perspective of starting something new, the committee at that time thought a full week would be better than just a couple of days.
Very good. Any thoughts on that?
Well, I think that I can see both sides of the coin. For courts like domestic court, where we go to court every Monday, if someone was using it for the wrong purpose or even for the right purpose, it could essentially keep a particular case out of court for, essentially 30 weeks, or well, 15 weeks, which could have some harm to the case or to the litigants who need to be in court for things like child support or child custody or some sort of emergency or more emergent situation. However, on the flip side, for instance, my husband had cancer treatments, and they were scheduled on a set day every single week for a number of weeks. And it would have been nice to have had a secure period, broken up over several weeks of time where I could have just taken a day. Luckily, it all worked out because of camaraderie, but I can see both sides, but I suspect that one might see the ability to take single day periods, cumulatively matching the 3 weeks, could essentially really have an arc on a particular case's ability to get heard if those strategic days were taken in that way.
That's a good example.
That is a good example. And it would seem to me that one of the things we may want to think about would be, if we choose to leave the 3-week policy in place, but give the chief district court judge, superior court judge, whatever court it's in, the authority to modify if somebody needs 1 day a week for medical treatment or something, to modify that hardcore week rule.
I would like to point out that under our rule, subsection 8, we sort of have a catch-all provision. It reads, nothing in this rule limits the inherent power of the courts to allow an attorney to enjoy leave that has not been designated according to this rule. So the courts are already empowered to allow this leave that Mel is talking about. And Mel, since you were part of the original committee, that's to your credit.
I get flooded with secure leave requests just because lawyers use it. And they tend to send them out at the beginning of the year when they know they've got plans. This is a question back to Mel. Mel, in balancing the flexibility of giving local judges the option of, or the ability to help a lawyer be efficient with the time off, will that create an administrative burden for the judges they just don't want to handle?
I think that's something that we should run by the judges, because we want to look at it from the standpoint, if somebody wanted to abuse the policy, do the judges have the right to deny and not allow that to occur? And I think that's why this is a good thing that we're doing now, is to look at things like that.
Yeah. Okay, so noted.
That sort of raises an interesting question. Do we want to send this survey to judges?
Good point.
Good point.
Yeah, I think if we're doing a survey that we probably should include them, Walter. I think.
And it
that's-
would need to be a different survey, obviously. But, you know, the district court judges, I'm sure, are going to see it different from superior court judges. And if we're contemplating appellate court, moving this into the appellate court, and probably want to get feedback from them too.
I would suggest getting the survey results back from the lawyers first, because we ask questions that relate to what lawyers are using the time for. And of course, the preponderance will probably be vacation. But in our small sample, we had a couple of responses that indicated the secure leave was used for medical purposes, which I suspect happens more frequently than people think, plus many other things that are not mainstream, but they're important. And that information may be of some interest to judges who get a survey based on what the lawyers are doing with their time. What do you think about that, Mel?
If we're going to modify it, I think that makes sense, particularly in situations where a judge has somebody that the judge feels is not using it the way it was intended, but is doing it to avoid hearing something or having something on the calendar when it should be. I like, as Cameron was saying, there was a catch-all paragraph to start with. As long as that's strong enough to allow a judge some discretion for somebody who is abusing or would attempt to abuse, I like giving the judge the authority to do that.
Okay. Very good. Anything else on this? I'm contemplating, once we get the answers to the survey questions back, spending pretty much of a whole meeting on possible modifications, things of that nature that need to be carefully thought through. But in the final instance, given what David Hoke said about local management of secure leave vested in the judicial districts, Mel, I understand the importance of making sure that it's approached that way. It may vary from jurisdiction to jurisdiction. I don't know that it does, but it may, and we need to be respectful of that, so judges can have a say. That's really important. May answer my question of, do you want to burden them with it? I think they'll tell you yes or no, or up to a point. Okay. Anybody else want to raise anything that is suggested to them by the Georgia program, or anything that comes out of some of our conversations that are derivative of that? Very good. Any other business to be taken up before the subcommittee today? Anybody have any special requests of staff counsel on this topic as a result of today's meeting or otherwise? If not, your homework assignments are to read the questions. And if you've got anything to change, please make it known. Send it to Savannah and Cameron and copy me, and we'll sure take a good look at that. I think I would like to set a May meeting date and time, but what I found out is it may be better for Cameron and Savannah to canvass you for those so that we can get a time that's available to everybody. We were missing some people last time and they didn't get the word, unfortunately, and or had planned other things. So we'll, instead of doing that today, set that later. And in any event, I hope to see all of you all at the quarterly meeting for April, even though it's going to be, again, remote. Anything else to come before the subcommittee today? Let the record reflect it's 2:59 p.m. Eastern Daylight Savings Time. We made it in just under an hour. Thank you all for your cooperation. Thank you for the work that you've done. Anything else?
Gordon, great to see everybody.
Yeah.